You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Rubble versus Rinker Materials Corporation.
May it please the Court. Good morning. My name is Melissa Visganti. I'm with the Ferraro Law Firm.
Can't hear you.
Could you speak up a little bit,
A little
please?
closer. Better?
I think something's happened to the sound.
May it please the Court? We good? Again, my name is Melissa Visganti. I'm with the Ferraro Law Firm, and we represent the petitioner, Joan Rubble. She was the plaintiff in the case below. Is my sound okay?
It sounds a little muffled.
No, it's
I think
speaker system.
it's an issue that's beyond
It's
your
kind of
control.
muffled.
Yeah.
Muffled?
It's probably not you.
I can step away from the microphone and speak loud if that's better. No?
Please, just proceed.
Okay. Your Honors, now I hear it. The primary issue underlying this case, and really the reason that this case is before this court, is the question of whether on the death of a plaintiff in a personal injury lawsuit, the personal representative of the plaintiff's estate should be permitted to amend the lawsuit to add allegations under the Wrongful Death Act, or whether that personal representative should be required to file an entirely new lawsuit and a new complaint to set forth the wrongful death allegations. As we indicated in our briefs, we of course respectfully submit that the answer should be the former. That is, the personal representative should be permitted to amend the existing complaint in the existing lawsuit in order to allege the wrongful death claims.
Now, in your case, I don't know, is this on? In your case, there had not been an answer filed?
Correct.
So really, under the rules of procedure, you would have an absolute right to amend.
Right. And
so are we, but you also, and I'm just trying to understand what's the big deal in this case, there, except for the filing fee, there would have been nothing to have prevented you from filing a separate lawsuit.
you're right.
I mean, there's no, so the policy issues of what in some of these cases that we're concerned about, like where there's discovery that's gone on, is not present here.
That's true.
But, okay, so I just want to understand the posture of this. So is it your position that it is a question of the interpretation of the Wrongful Death Act and the concept of abatement, or it's a issue of the proper procedure and it's a procedural issue?
Well, initially, in this particular case, this case really does come to a procedural issue. In this case, the answer is all the more compelling because of the fact, as you indicated, there was no answer filed in this case. There was no response. So the petitioner, the plaintiff, had a right to amend as a matter of course. Now, the decision and the arguments by the defense, the decision was based on this right to amend to add the wrongful death claim. So then we moved a little less of a procedural issue. It moved into more of a substantive statutory interpretation issue, you could say. Again, our position is that the reasons here, the reasons why a petitioner or a plaintiff should be permitted to amend the complaint are compelled by the wrongful death statute itself.
But, okay, so let's get to the wrongful death statute itself, which talks in terms of once the plaintiff has died, that is there no longer a cause of action for personal injury, correct?
Correct.
And that the action is abated. And so it comes down in my mind is, what does the term abate mean?
Right, and that's really the big
question. So what do you maintain that the term means?
It's been, our position from the beginning has been that abate can mean extinguish, abate can mean, a hold, a stay. But whatever it means, it doesn't mean, let's say it means extinguish, which we were, as we briefed, it's not a problem for us if that's the interpretation, but it's not.
But even that term, extinguish, brings up the idea of what are you extinguishing? Are you extinguishing the personal injury action, or are you extinguishing the case in its entirety?
And our answer to that is you are not extinguishing the case in its entirety. This is the most significant distinction here. The act acts to extinguish only that personal injury claim by that decedent. That decedent can no longer proceed with a personal injury claim.
And if that is all that is alleged in the original lawsuit, all that is alleged is a personal injury action, then where are we?
Then within a reasonable...
there's no loss of consortium claim, there's no anything else. What happens to that lawsuit then?
Then within a reasonable amount of time, the personal representative needs to amend the complaint. In our case, that's of course not the circumstances of our case, because the plaintiff, Mrs. Rubble, was a party. So she was already in the suit, and she was the one who moved to amend because she had the loss of consortium claim. She moved to amend to add herself in her capacity as the personal representative and to add the wrongful death allegations. But in the circumstances you're raising, it's to us no different than in a case where a motion to dismiss is filed because, for example, a failure to state a cause of action. Now the complaint, the cause of action...
To me that it's even more it would be more compelling in a lawsuit where all you alleged was a personal injury action, that the logical thing to do would be to then file a wrongful death action, as opposed to amending a personal injury action.
Well, respectfully, we disagree there. To us, the logical thing to do is to allow the amendment. Why have this extra procedural hoop, this procedural obstacle that we need to go through to start an entirely new lawsuit?
Well, isn't it more basic to me, and this is the purpose of the wrongful death statute is not to prevent a plaintiff from being able to sue a tortfeasor. It's actually in a way to protect the tortfeasor from a multiplicity of actions after someone dies as a result of the underlying tort. So really, and it may be too simple to look at it this way, if you look at the legislative scheme, it's essentially taking your allegations against the tortfeasor are identical. What wrong was committed? Was it a negligence action, strict liability, whatever? It's the damages that are now changed, that instead of you being able to sue for pain and suffering for the decedent, those damages are transferred. And I think when looking at Judge Altenburn's opinion, when you look at it really that way, that's in every case where we've interpreted the wrongful death statute, the idea that the legislature would have said you really don't have a cause of action against this tortfeasor. That's not what they said. They said the damages are now are changed. Now you have wrongful death damages.
Correct. We agree. And our complaint in this case is a perfect example of that. The original complaint and the amended complaint that added the wrongful death claim, they're identical. There is no change to the causes of action. There is no change to the allegations. The only thing that changed was the addition of the wrongful death damages. In our particular complaint, the plaintiff still set forth the original claim for damages. She still had her loss of consortium damages. She still had her survivor damages in there. Because in that case, of course, there was no answer, so there was no position by the defendants as to what the cause of death would have been. So we absolutely agree. Why? It's exactly the same thing.
But then that's why I asked you whether this was a question of procedure or a question of the wrongful interpretation, because procedurally there would be no reason that the court system would, except if they want the additional filing fee, would want a plaintiff, an injured person who's now, and in some situations you may not even know whether the cause of death was, whether it was related or not, and you have to be able to plead in the alternative, to want to require a separate lawsuit with separate service of process. So that's why I think that's the procedural part as to whether it is the intent of the procedural rules that a plaintiff should have to file a separate lawsuit or can amend the existing lawsuit.
Right.
And what's the authority? I mean, and so if we go back to procedure, where do we come out on the procedure?
So procedurally, of course, the Florida rules of civil procedure are very clear that with respect to the amendments, of course, the right to amend should be freely given. It's the rules themselves have an overall intent that they should be interpreted to affect the speedy, to affect justice without delay. I mean, all of the intent behind the rules of procedure and specifically the rule with respect to amendments compels the ability to amend in these circumstances, not to throw up an additional requirement. Then, as I said earlier, then you add in, on top of that, the Wrongful Death Act. Now, of course, the Wrongful Death Act is the statute, and as we indicated in our briefs, the Wrongful Death Act should not be adding more procedural requirements. That's something that should be and is addressed in the rules of civil procedure, not something that should have been an additional procedural hurdle, should not be something that's put up through this statute. So at the end of the day, the rules of procedure, we could stop there. And in our particular case, the court probably should have stopped there way back when this was in the trial court. We probably never should have even gotten to this issue because, again, where we started, there was no response to the original complaint. This plaintiff had the right, as a matter of course, to amend her complaint.
Who may bring an action is different, perhaps, in some cases when the person who's been injured dies. The personal representative for an estate may be a different person than who may bring the action when they're still alive. Would you agree with that?
Correct. The person who may bring the action originally, could be the survivor, the plaintiff himself, the injured person.
And even if it's the same person, they'll be in different capacities.
Correct.
So in that sense, there needs to be a substitution of parties in addition to an amendment of the substantive nature of the claim.
Correct.
And is that a matter of right as well, or no?
Well, in this particular case where there was no responsive pleading, yes. The plaintiff is entitled to drop or add parties if you want to consider it an addition or a dropping of a party. Because remember, in this case, Mrs. Rubble was already a party, so you could look at it as adding the personal representative. But also, there's 1.260 provides the right to substitute under certain circumstances. Now, whether that applies in these circumstances, of course, that was briefed. 1.260 is the substitution of parties upon a suggestion of death.
So, and that's a matter of right that doesn't require a court order?
Well, if you're proceeding under 1.260, no, the statute, the rule does provide that you need to move to substitute and get permission from the court upon a suggestion of death. Now, in this case, there was no suggestion of death, and I will then fall back to the fact that in this case, the substitution of the party was happening as a matter of course, yes, because of the liberal right to amend the pleading at this early stage before a responsive pleading had been filed in the case. I think that the situation would have been different had the case been a little further along, had there been a responsive pleading, had there been further litigation in the case. But in this particular case, no matter what happens on the issue of whether there's a right to amend to add these wrongful death claims, it's important that I, continue to emphasize that for Mrs. Rubble's particular case, she, of course, had the right to amend as a matter of course anyway.
Could you address the basis for our conflict jurisdiction in this case?
Yes. The petition for the jurisdictional petition was based on the conflict with the 2nd District's decision in Miami. So there was in the 3rd District the Capone decision.
Well, but why isn't that case just factually different? Because there was uncertainty about the cause of death, that no one was taking a position. that this was going to necessarily be a wrongful death action. They didn't know what it was going to be. And isn't that a distinction?
There are definitely some factual differences between the circumstances that case presented and the circumstances that this case and the Capone case presented, but the holding in the case was an overall statement that, and of course the statement that we like in Niemi, which is that it doesn't, no matter if there was a surviving alternative claim or not, the personal injury action, though it may be extinguished by the death of the plaintiff, does not extinguish or just self-destruct the entire lawsuit. In Capone and Rubble, the third district was flat out holding that you cannot amend the complaint to add a wrongful death cause of action under any circumstances. So Niemi would have allowed the amendment in Mrs. Rubble's case. The third district, with their decision in Capone and Rubble, under no circumstances was going to allow Mrs. Rubble's amendment in that case. So although the factual scenario that was presented and described by the courts was different, the holding in Niemi would have directly resulted in a different decision in our factual circumstances.
You are now down to about 3.5 minutes of your total time.
Thank you.
May it please the Court, I'm Larry Klein. Justice Polston, they say they have a right to substitute, but the very rule 1.260 says if a party dies and the claim is not thereby extinguished. And of course, under a wrongful death statute, the PI case is abated. And in Niemi, contrary to what they say, Niemi says abated means extinguished. These things all work together. There's not a single case that has ever addressed the specific issue here and said you have a right to amend. The cases say you do not. There are some cases that they've relied on in which it was a fact, either by waiver or stipulation, that the amendment was allowed. But in every case in which it has been addressed specifically, it says no, and it makes sense. A wrongful death action doesn't even exist until the person dies. And a wrongful death action has a 2-year period of limitations in which to be filed.
But why does that make sense where the same, and I understand what you're saying about the substitution, and that's why I asked, do you see this case as being an issue of interpreting the wrongful death statute or interpreting our rules of procedure as to whether amendments, when a person dies as a result of the underlying tortious conduct, amendment is preferable to requiring a whole new lawsuit? So is it a procedural issue or is it a substantive issue of interpretation of the Florida's wrongful death statute?
I think it's a substantive issue. I think because the statute says abated, that answers the question.
But what the Martin case, the case that from this court from 1975?
Yes.
You're familiar with that. Doesn't it talk about that the idea is it merges the survival, it actually says it, the survival action for personal injuries and the wrongful death action into one lawsuit, and the idea being that it's really in a way to protect, as I see it, the defendant from after someone dies from, are they going to have 5 different lawsuits or are they going to have one lawsuit? So it doesn't make sense to me that with the policy underlying the wrongful death statute that the legislature would particularly care if it should be a separate lawsuit or amend the existing one that's where service has already been perfected on the defendant and where maybe discovery has been taken of the request for admissions, interrogatories. Why the legislature would particularly care whether that was brought as a separate lawsuit or an amendment to an existing one?
Well, I think one reason is there's just no precedent for allowing an entirely new cause of action that didn't exist previously with entirely new parties. You could have a personal representative, not, in this case, it's the wife who was in the PI case, but in another case, it could be a bank.
But what's the it's entirely new as to the damages. It's absolutely the identical cause of action as to the tortious conduct of the tortfeasor. There isn't, so this idea, the idea is that the damages, and I understand,
and the people that can recover damages could be different.
There could be more
Yes.
people that
Yes.
could recover.
Yes.
So, but again, let me ask you this question: if this was one where it was not sure, you weren't sure whether the death was the result of the underlying cause of action, are you saying that the rules and the Wrongful Death Act would require a wrongful death statute action to be filed separate from the personal injury action?
Well, that was a problem in Nimi.
But what do you think about that one?
In this case, we know.
No, but what I'm asking you is because you're saying it's entirely new. So if somebody doesn't know, do they have to file a separate wrongful death action and keep their survival action going? Or are they allowed to amend in that situation?
Well, I think until it becomes determined what was the cause of death, that you can't say. And I think
that may be a jury verdict. The jury may be forced to make that decision. You could go all the way to judgment, couldn't you? To a jury verdict, not to judgment. You could go to jury verdict. The defendant is contesting the cause of death. Plaintiff takes one view. Defendant takes a different view. You submit that to a jury, and the jury decides either a survival action or wrongful death, and then the court would enter judgment accordingly.
Well, Your Honor, I really don't have an answer for that.
But isn't that the way it would happen?
But we do know.
Is that the way it would happen?
It possibly could. But you could also alleviate that problem by following the existing case law, and when the plaintiff dies, simply go ahead and file the separate wrongful death action, which isn't a big deal because they have to amend the complaint
then you'd have
anyway.
two cases going then. So you're saying two cases?
They could, yes. They
so
could.
you'd have two cases
Yes.
under that theory. But
Yes.
I'm trying to understand if a party files a legal action, and let's say that the action does not exist as a matter of law, and the lawyer has just missed his or her cause of action, and a defendant brings it up, makes the argument, and they go to hearing on this, and the trial judge says, I agree with the defense. And the plaintiff says, well, I would like the opportunity to amend. Underlying cause of action doesn't exist. Does that trial judge dismiss it and say you have to refile it? Or does our law teach us is that you should be able to amend that to state a viable cause of action, if you can?
If you can, Your Honor, but it's sort of a circular problem because we're getting back to...
It's a circular problem because of the argument that the defendants have made. We've been doing this under the statutes in, 1972?
Yes, Your Honor.
This has been a long time.
You and I and everybody in the PI field knows from their experience that you do file the new lawsuit, and that's what the cases have held. In the AC...
Well, I beg to differ. What the experience tells us is no, you don't, is that you file the notice on the record and you amend the lawsuit and you go on forward from there. You don't file a new action.
Well, my experience was when it's the defendant that dies, you file the notice, but when it's the plaintiff, you have to file the new action, and that's what the third DCA decision told this trial judge to do. And all they had to do was file it, and 2.5 years ago, and we wouldn't be here.
Well, that seems, and there is something, I guess, in this case and the other case we're hearing, sort of the frustration about, what's the big deal, so to speak. But I don't understand. Let's just go back to what's the big deal for the defendant. I want you to put on the hat from the defense is saying, we'd much rather have you file a separate lawsuit and serve us again so we can call up our lawyer again and have our lawyer tell us whether, what to do. I don't get it. In other words, I don't get the efficiency of once you've served somebody and that the cause of action is arising out of the same identical facts. It's even, to me, stronger than the other scenario. I'm just not getting either the policy for the legislature or the policy under our rules to why it doesn't make entirely more sense to have it be an amendment. And I don't remember that, again, to say, it's just, I just don't understand it. So explain, the defense hat is, yes, you've got to go back, pay your filing fee, and file a separate lawsuit. Why?
Well, my answer is, obviously this court has control over the procedure, but we have the statute that says that the personal injury case abates, and it doesn't explain how it gets started again. It simply says that it abates.
So
and
there
I
it
think
is.
that
So
statute destroys that case. It extinguishes that lawsuit.
It doesn't, but here is we can say destroy, it sounds again like the Judge Altenburn said, it doesn't self-destruct. The purpose of the wrongful death statute is to preserve the underlying cause of action for the tortfeasor. So the decision for the legislature is allow a survival action to continue or have the damages transferred, and the damages change in nature, but the underlying lawsuit, the liability, if you're not at fault, and let's say it was a terrible automobile accident, it was the plaintiff's fault, you're still not at fault. It doesn't somehow transfer into you become at fault. It's the same liability. So that's why I don't get the separate lawsuit.
The liability is the same, but the plaintiffs are different. You're going to have different.
But where's the prejudice to the maybe that's, let me ask it that way, because that's what these amendment cases talk about. Where is you said it would be so simple for them to have filed a separate lawsuit, and I agree. Okay, it would be so simple. But where's your client didn't even answer. Where's the prejudice to your client where they would be saying, no, please serve us again? I don't get it.
I can't tell you that there is any prejudice, Your Honor. But I think this is something that you need to think through if you're going to do this, because you get certain things that happened in the first lawsuit with one lawyer, and then there's a death.
But one of the things that you ought to think through, I mean, this case may be very simple, but the next case may not be very simple. You may have a case that has gone on for a year or so before the plaintiff dies. There may be all kinds of depositions that have been taken. And if we're talking about the death having occurred based on the same allegations that were made in the personal injury suit, where's the efficiency in having to redo all these depositions and those kinds of things? I mean, that's one of the issues that bothers me when it comes to a case in a little different procedural posture.
Well, Your Honor, I don't think you would have to redo the depositions. You could use those, but you have things like you might have a 57105 notice in the first case. You might have an offer of judgment in the first case. You have tactics used by the lawyers in the first case on the plaintiff's side, and then you have a new party coming in and taking over the case, and they may want a new lawyer if a bank becomes a personal representative. And I just think these are things that it's easier to continue with our present system. I'm not saying that it helps. We don't really, it's not a big deal to be, probably we waive service in the new one. That's not a big deal.
Seems to be some dispute as to what the present system is, because as I read the amicus, it seems to me that, well, maybe not the amicus, but it seems to me there's an allegation that that the practice, at least in some places, is that you do amend the personal injury action into a wrongful death action. I mean, is that a statewide practice, or is it done different ways in different circuits, or how is it done?
Well, all I can say is that there are cases in which it has happened because we know from the factual statements. But we don't know of any case in which it's been an issue, in which it's been allowed.
I just want to...
Well, nor denied, other than that's just developed recently. There's just no case law on it. Could I ask one question? Could you superimpose a statute of limitations on this, and the first case bumps along, and it's a lengthy litigation. Statute of limitation runs, and then if you're saying that this is a totally new case, who gets the benefit of the statute of limitations for the new case?
Well, once the person dies, this 2 years starts to run.
2 years, no matter if they've litigated the negligence case for 4 or 5 years and statute of limitation has expired, then death gives you a new cause of action.
Absolutely.
Okay, well, then let's say that no action is ever filed and then death occurs 6 years after the injury. You're saying that you get a new statute of limitations for the death? Is that Florida law?
Yes, sir. I'd say if that injury caused the death.
Okay, so there's no statute of limitations issue in your view that would come in to be superimposed on this.
Absolutely.
To make a difference.
Yeah, I couldn't figure out why this case even got any interest by this court, but it became apparent that they've cited a couple of tobacco cases, Engel cases, in which the courts have voiced concern, a U.S. District Court case out of the Middle District and the case out of the 2nd DCA. But those cases never even got so far as for the first case to be over. They tried to amend in the first case, and then the courts began to worry, well, Engel gave a 1-year period, but that 1-year period started 4.5 years ago in Engel, and no tobacco case has been dismissed that we know of. And it's not a problem, and I think you're going to hear more about that in the next case.
Let me go back to your concerns, and as you give those concerns, you're talking about it as sort of the policy of how would the courts deal with it. 57105, that's for frivolous lawsuits. Does a lawsuit which looks at the liability? So if we took, one of the famous cases of the McDonald's and the hot coffee. If that was a frivolous lawsuit, but she died as a result of those injuries, would the lawsuit become either less or more frivolous because she died? I mean, I don't see where what I'm saying to you is I'm not sure I understand why the 57105 fees, if it was a frivolous lawsuit, it's just as, now what would make it, maybe it might change it if they didn't die as a result of the underlying case and someone's trying to make it into a bigger case. But, that would be a fact-specific situation. I don't see how that really helps the idea that I filed the wrongful death action, but I'm still not sure about the survival. And then I moved to consolidate the cases, right? I could do that. Do you think there would be any judge that wouldn't consolidate if you were looking at survival and wrongful death and not sure about which one, wouldn't consolidate the two?
I think that's only fair. But let's say you have the case like this one, so that you have a 57105 notice in the first case, and then under the statute, that case is abated, so you file a new lawsuit under our current system of the cases that we have. So you file a new lawsuit. What is the effect of the 57105 in the first, as opposed to just letting them amend or an offer of judgment?
But under your scenario, actually, it would be better for the defendant if it continues, because if it's frivolous and they then somehow see that they've, you don't really, may not know until you actually go to trial. Well, if they amend and they change, they file a new lawsuit and sort of change some tactics, then maybe your client never gets the benefit of being able to get the 57105 attorney's fees from the first lawsuit. So I'm not sure I see how that scenario that you've come up with would actually even help the defendant to prevent a lawsuit. If a lawsuit's frivolous once, it's going to be frivolous.
I'm not trying to protect the defendant. What I am suggesting is that this could be opening a can of worms. You have the 57105 in the first case, and then it's over because the plaintiff dies, and then you have a new wrongful death lawsuit with a different lawyer representing the estate, and then another 57105 comes in, and then that lawyer says, hey, that first lawyer didn't really evaluate this case properly. This is a frivolous lawsuit, and we will drop this lawsuit within the time of the notice. Or you could get an offer of judgment in the first case.
But you could do that if they amend it, and the second lawyer says, now I've amended it, even though I think I'd have great damages, I don't see there's any underlying liability. I'm dismissing the lawsuit. I'm just not seeing how that, what you said, would change whether you allow the amendment or a separate lawsuit.
Well, the question is, does a 57-1, if you allow the amendment, does a 57-105 carry into the new amended lawsuit? Does an offer of judgment come into the new amended lawsuit when you actually have a new plaintiff who is entitled to make their own decisions about how to proceed in this lawsuit?
I can see how those are very different things, counsel. What would be wrong with having the rule that the trial judge looks at a proposed amendment and substitution of parties and makes their judgment based upon where they are in the case and what other claims there may be in the case? There may be other counts where it would make, or situations where it wouldn't make as much sense to file a new lawsuit, but to keep it in and have a substitution. And there may be other cases in which, perhaps like this one, where it makes no sense to have anything other than a new lawsuit. So it seems like there could be different circumstances in different cases and not have some sort of blanket rule where the whole case gets dismissed, but perhaps that claim is going to get dismissed according to the statute. But as to whether or not there's an amendment permitted or not may depend upon the circumstances of that case.
Well, but that would, in other words, we're getting away from a rule. Here we have a hard and fast rule. Everybody knows what to do, assuming that my version of the rule is correct. Under your version,
didn't a great many people think that their version of the rule was that you amend, and that was hard and fast, and that was the rule?
Well, if you want to make a hard and fast rule that you can always amend, then that's something else. And as long as you can construe that statute and the
well, what would
intent
be wrong with, I mean, in our process now, in our rules of procedure, we have some discretion afforded to the trial judge. What's wrong with that?
Well, the discretion they're talking about, though, doesn't contemplate an entirely new cause of action with a different plaintiff. And that's the reason the discretion doesn't come. You should either be able to do it as a matter of law or not, because the question is, you have a new party and you have different damage claims, and that's the issue. It shouldn't be discretionary, because then it's just you're going to get more confusion, and what you need is a hard and fast rule for every case, I think. Thank you.
Thank you.
Your question was, is this a procedural issue or is this a statutory issue? Now, in thinking through it further and listening to more of your questions, hopefully I can answer this better. It's a procedural issue. The rules of civil procedure dictate that the plaintiff should have been permitted to amend. A plaintiff should be permitted to amend in these circumstances. The wrongful death statute had no intention of changing that or interfering with that. This is a remedial statute. It is not there to make things more difficult for either party.
Well, if it's an abuse of discretion standard on an amendment, where is the abuse of discretion? There is no prejudice to you.
Well, the prejudice to the plaintiff here was that she now has to file an entirely new lawsuit. I understand. In this particular case, it doesn't seem like the prejudice is all that great. It's a filing fee and service on a few defendants. But this particular case, and you asked in the beginning, why? Why did the plaintiff not just file her new wrongful death case? You know, she had, by the time the order dismissing the case came out, this had been litigated for almost 2 years, this issue. The decision was wrong. The plaintiff knew it. The plaintiff's lawyers knew it. And it had a tremendous impact. Remember that if you take a look at the statement of facts that we laid out in our brief, the hearing on this issue was not just a hearing on the Rubble case. The hearing on this issue was at the Miami-Dade County Asbestos Monthly Calendar. The judge specifically said, I'm going to defer ruling the first time this came up because I want every asbestos lawyer with a case pending before this court to chime in on this, to state their view on how this should go. That right there signaled to everyone the impact that this was going to have, not just on Ms. Rubble's case. And remember that this procedure of amending the complaint, and this came up, this is how it's been done. This has always been the procedure. It has never been an appellate issue because the right has never been denied before. You brought that up. This is not something that's come up before because it was never denied. This is the way it's always been done. The plaintiffs and their lawyers in this particular case were literally blindsided by this ruling. And then to have it come up now in front of the entire asbestos bar, this was a potential change in a policy and a procedure that's been going on for years. And then to add to that, it now comes up in a tobacco case over and over again. This is something with significant impact. This is an important issue. So why not just go ahead and file the new lawsuit? Because the lawyers and the plaintiff appreciated the significance of this issue. Had she filed her new lawsuit, she risked that we were going to have the third DCA would lose jurisdiction over the issue. And, of course, after almost a couple of years of litigating this issue, what happened in Taylor was a potential problem. She was now potentially going to be splitting her causes of action and lose the availability of an appeal of this issue should something happen and her wrongful death new case get dismissed. So it was a big deal for the plaintiff.
And not only that, with the new lawsuit filed, there's a possibility you have a different judge.
Of course.
And it would not be efficient to have it in that posture.
Completely inefficient. I think that we've addressed all of the questions from this court. If there's anything else, I'm happy to address it. But otherwise, thank you very much.
I apologize to the court and to the counsel for my unprofessional behavior of the telephone. I didn't realize I had it with me. I apologize to all of you.
We thank you both for your argument. The next case on our docket is Capone versus Philip Morris, USA.
Good morning, and may it please the court. I'm John Mills on behalf of Karen Capone, the petitioner in this case. The issue is largely the same in this case. In fact, the procedural posture is just about the same because there was no answer filed in this case either. There was a motion to dismiss the original complaint, never an answer. Plaintiff moved for leave to amend.
But there was an answer in the original.
No, there was not.
No?
There was a motion to dismiss, and in Forum versus Bokeberger, this court made clear that a motion to dismiss is not an answer.
So this case had been pending for, the underlying PI case had been pending for over a year, and a half?
This is one of several thousand cases in the Florida system now that's in this posture because it's an Engle case. There's 8,000 Engle cases. They can't all be tried at once. So in each of these courts, you have sometimes the court stays everything in a case. Sometimes the plaintiff and the defendant reach a standstill agreement. So the case is just kind of sitting there. Sometimes people don't even know when the plaintiff has died because the case, there's been nothing going on because there's so many cases in front of it. So that's kind of the backdrop of an Engle case. But this issue is not an Engle issue. This issue arises in every personal injury case where the plaintiff dies. And I just want it to be absolutely clear that the action does not abate, even under the wrongful death action, unless and until there's a determination that the death was caused by the tort. You can't know that. If it's not caused by the tort, then the action continues. It's a survival action. And you can't know that until at least two things have happened. At least, and usually not even until after that. You have to have a complaint where the personal representative makes an allegation and says, we allege that the death was A, caused by the tort, B, not caused by the tort, or C, we just don't know. But that doesn't determine anything, contrary to what they put in their answer brief. Your allegations in a complaint, I mean, unless we want to change our pleading system and say that plaintiffs can establish facts by pleading them, we don't know any of those facts are true until they've been decided to be true. So the next step is an answer is filed. And if in the answer the defendant disputes the cause of death, even if the plaintiff said, absolutely beyond any shadow of a doubt, I know that this decedent died as a result of the tort, and they put that allegation in their complaint, and there's not even an alternative allegation, the defendant has the right to come in and deny that and say, no, he didn't die because of these injuries. He died for some other reason. He died because he had pneumonia unrelated to his lung cancer, because he got sick from being around his grandchildren. There can be all kinds, or it was injuries from a car wreck. So until you have the pleadings closed, you can't possibly know whether it's a wrongful death action or a survival action. And if there's any dispute, then you don't know until you go to trial. You may get a decision by summary judgment.
Is the third district decision, because it seemed like a blanket decision, that even when you do not know whether the death was related to the underlying tort, that you still must file a separate wrongful death action?
That's absolutely what it says. It says you cannot amend a personal injury action to add a wrongful death claim.
Okay, so what that you would then the rule would be, because and I don't know if the tobacco defendants agree, but on the last lawsuit the agreement was it's 2 years from the date of death. You have 2 years from the time someone dies.
Well, not when you already have filed the action. I mean, that's if you don't have a pending action. If you already have a pending action, then you have in essence, you have two statutes of limitation with a wrongful death claim. The underlying claim has to be timely. So whoever asked the question earlier, I think it was fumbled by the defense, there's not a new statute of limitations. The underlying claim still has to be timely. So you do have to look at the underlying, could the plaintiff have timely brought this action? So if that statute's expired, then it's too late to bring a wrongful death action.
I guess I'm a little bit confused with that, because it seems to me that if you're going to file a wrongful death action, how does your cause of action accrue until the death itself has taken place? And
yeah,
so
you can't. Well, right. Obviously, you can't file the wrongful death action before the death. But if you already have the lawsuit pending, you've already initiated, the defendant is well aware, everybody's saving the witnesses, everybody knows everything about the conduct. This is about something that happened in the past to the plaintiff before he died. So the only difference is now the plaintiff has died, and you have to bring the wrongful death action, and there is a separate 2-year statute of limitations, so you have to bring that within 2 years.
2 years of what?
Of the death.
Okay, so that's so you bring your separate lawsuit. We'll go back to the statute of limitations, and then you would move to consolidate.
You can, and that's what everybody's having to do since Capone has been issued.
Okay, but there is no judge under the rules. It would seem like there wouldn't be any discretion. You would have to consolidate those causes of action.
Oh, I think there's always some discretion, but no more than they shouldn't have discretion to deny an amendment here for the same reason. It makes no sense. There's not been one policy argument made to this court. Justice Polston, you asked about it, but there hasn't been an argument I haven't heard. What's wrong with, what is inefficient, what could possibly be a reason to not allow them to proceed in the same lawsuit, whether it's by an alternative claims in the beginning of the complaint or by a consolidation if for whatever reason they've been forced to file 2 separate claims. It would be horribly unfair and horribly inefficient to have 2 separate lawsuits. You would never want that.
Go back to the statute of limitations issue. I think it was Mr. Klein that said you have 2 years from the date of death, and therefore even if it was 6 years after the original action, until you die, that cause of action doesn't start. So even if you had not filed the underlying personal injury action and you were untimely, it was more than 4 years, do you agree that there is another 2 years you have?
I would like that to be the case, but no, I don't think that's the case. I don't think a wrongful death case can revive a stale personal injury action. If the underlying action was time-barred, I do think that there's case law that says if the underlying action was time-barred, the wrongful death action doesn't restart that. And that the flip side of that is if you already have the action pending and you're moving to amend, we moved to amend within 2 years. The second issue in our brief was whether the motion to amend, whether the wrongful death claim would relate back. That really only, as pointed out in the answer brief, that doesn't really apply in this case because here we did file our amended complaint within 2 years of death. But even if you didn't, it's the same lawsuit. It ought to relate back. That's not really an issue before the court right now because of the concession that was made. But it's the same. There's no prejudice. Everybody knows, especially in these Engle cases, the defendants know that all of these plaintiffs are going to die. They all, by definition, have fatal diseases like lung cancer and COPD. And there's 8,000 of these cases. They're not all going to get tried in their lifetime. So at some point, all of our Engle cases are going to be wrongful death cases.
Mr. Mills, it seems that the position of the defendant is that if you do not know about the cause of death, then you can plead in the alternative.
They've admitted that here, finally, which is astounding because that's exactly what we did here. This amended complaint says it is the plaintiff's position that the death was caused by smoking. But recognizing that the plaintiff doesn't get to make the facts, the plaintiff says in this complaint, if the defendant denies that, then alternatively we're maintaining our survival action. And unless this court is to say, as it's been remarkably suggested in the answer brief, that the defendant doesn't get to deny the cause of death and that the plaintiff's allegation controls, then their argument falls apart. You have to have. It had to be allowed here. There was no discretion to deny this.
If the statute of limitations is not the issue, and everyone agrees that the filing in the alternative is not the problem, can you give us what you see as the policy reasons on both sides of this argument?
Sure. The only policy reason for the defense side is for the judicial coffers to get an extra filing fee. I don't see any other policy at all. It's all based on language, torturing. What does abate mean in the wrongful death action? What does extinguish mean in 1.260? Those are linguistic arguments. Those aren't policy arguments. The policies on the plaintiff's side, let me just give you a hypothetical that will set it right out. You have a fraud claim. The fraud claim is brought 4 years, just under the statute of limitations after the injury occurred, and 11 years after the fraudulent statement was made. So you're at the end of the statute of limitations, you're at the end of the statute of repose, and you timely file your fraud action. Your plaintiff does. And it's a big, complicated case. There's a motion to dismiss, and that's granted. And there's an appeal, and it goes up to the DCA, and it gets reversed, and it comes back down. And you proceed to discovery, and you have 2 years' worth of depositions. And no, depositions can't be used in another case. That's the evidence code talks about that. So you have your depositions, and then you go to trial, and it's a complicated trial. It takes 2 months. All the evidence is in. The jury's been deliberating for 4 days. And before the jury comes back with the verdict, the plaintiff keels over and dies as a result of the injuries caused by the fraud. Under their view, the case is over, it's extinguished, it's abated, throw that away. The PR's got to start all over, file a new lawsuit. Well, first off, right away, the very first defense is you're barred. You're barred not by the statute of limitations, because the underlying claim was timely and you brought it within 2 years. You're barred by the statute of repose, which says you can't bring a new action, can't bring a fraud action more than 14 years or 12, whatever it is, after the fraud occurred. So now you've got this new case that's time-barred ab initio, unless you create, in the answer brief they say you can create some tolling rules. I don't know how you create tolling rules to the legislature's determination to put a statute of repose in, but even if you could, I don't think that's very practical. You'd also have to amend the rules to allow the depositions to be used. Now, what about this appeal you had? You had an appeal. That's now meaningless because that was in a different case. You don't have any res judicata issues because you didn't get the final judgment, and you got different parties anyway because now you got a PR instead of the plaintiff. You've got all kinds of problems here that are absolutely unnecessary. And Mr. Klein, with tremendous respect, he was a fabulous plaintiff's attorney before he took the bench, and a distinguished jurist, but he can't remember how it actually happened, because it is the Florida Justice Association has filed a brief saying it has long been, as I think many of these members of this court know, it's long been the tradition. Everybody does this. You amend, maybe not if it's right when you started and it hasn't been served like in Rubble. I mean, maybe they could have just done it just as easy then, but that never happens. You've got your filing fee, you've already paid it, you've already perfected service, you've already got a judge. You don't want a system where you can go get a new judge. Well, gee, I don't like this judge. I'd like to go file a new action to draw a better judge. You don't want to have that. And that's why it has, and we've given you cases that show, yes, they're not holdings. They just say that's the facts that came before the court. But it's extremely common, and this is the way it's always been done, until we had a fifth DCA decision called Taylor that kind of started the confusion. And Taylor, they actually had filed the 2 separate actions. So the DCA was dealing with a case where there were already 2 separate actions, and the defendant was complaining. You know what they were complaining? Splitting the cause of action. You can't do that, which is probably right. And the DCA just said, well, there, you've already got 2 actions. Let's just go with the newly filed one. But they had some language in there that said you can't amend. And so the defendants have seized on that. And in a series of trial court orders that are attached to the motions here, they got some Miami-Dade circuit judges to start agreeing with them on that. And that's the first time that ever happened in the whole state since 1972.
Before you sit down, don't you have another problem with regard to the timing of a filing of a motion?
Yeah, that's another issue.
Well, but that's still, there's 2 holdings as I read the third district case.
Yes, absolutely, and we have to knock that one down too.
Well, I'm concerned with the second one.
Okay, well, I don't.
If you win the first one.
Sure, thank you. The second one, I really don't think that there is a problem there. The question is, the DCA's holding was that the motion for rehearing from the original dismissal, the 2008 dismissal, was untimely filed. That's their holding, and that holding is wrong on its face because filed doesn't matter. It matters whether it was timely served or not. And to the extent
wasn't there a question about whether it was actually
Well, there
served?
was a question, and the question was absolutely resolved in our favor if you look at the evidence as opposed to what attorneys said. Here's how it came down. At the original hearing, the first hearing that was dealing with this issue, it was first raised at the motion for rehearing of the 2008 order, and then it was raised again. That motion was granted. Philip Morris moved to vacate that order, and there was another hearing that was raised again. And at that time, this is just really disingenuous if you start to think about it. There's 2 defendants, okay, or 2 lawyers representing the defendants. One of them comes forward and says, it wasn't timely served. Look at this postmark on this envelope. That's their sole basis for saying it was untimely served, was that one of the envelopes had a date that would have been after the 10 days. Mr. Fitzgerald, the plaintiff's attorney, said, I am quite sure I mailed it from Virginia on the 24th or the 26th, whenever, timely, and it could not possibly have reached Miami on the same day it was docketed on the 29th. So he says, I don't know why their envelope is that way. He said that's not my envelope, but all of this was unsworn, all unsworn, and the judge ends up saying, and the other thing was the certificate of service in the judge's copy. They're in chambers for hearing, and the judge's copy has a blank certificate of service, just like almost all of the pleadings in the appendix to the answer brief here. That's because Mr. Fitzgerald did not make photocopies when he signed something and sent the original in. Instead of making a photocopy, he just printed it up and mailed to the court, to the judge as a courtesy copy, and to counsel blanks, just printed up. So he did that, and they looked through the court's file, the judge's file, and they found the cover letter to the judge, which was signed, and attached to that the blank motion. And Mr. Fitzgerald just said, well, I don't know. Maybe I forgot to sign it. I don't remember. It happened when I had health problems in my family. I'm not sure, but I am sure I served it on time. I'm willing to testify to that. Court didn't take any testimony, and it just said it denied it as untimely. Within 10 days of that, a motion for rehearing of that order, that September 2009 order, was filed, and it was verified. And for the first time, we have competent, substantial evidence. We have sworn testimony by a lawyer who says, I swear, under penalty of perjury, that I mailed it on the same date that I've been saying all along. And in fact, I've now solved the mystery of the envelope. The reason that we have this envelope with the wrong date is because I mailed that to Bruce Weil, and the post office or whoever, somebody misdelivered it to Kenneth Weil, who's in a different law firm, the Brumbaugh firm. And Mr. Brumbaugh took that, said, this isn't for us, put it in one of the Brumbaugh firm's envelopes, put it through their postage meter. They even matched the numbers on the postage meters to show that he just forwarded it on, and that's why one of their copies had that.
Was there jurisdiction to consider a motion for rehearing of the denial of the motion for rehearing?
There wouldn't be, but that's not what this was. This wasn't a motion for reconsideration of a denial of rehearing. The rehearing had been granted, and a year later, after it had been granted, the trial court entered a new order vacating it. And it's not even as saying that that first order was wrong. We're saying we're not addressing anything in the second order.
There's no substance in the second, which is merely an order vacating an earlier order.
That's right. Okay. And it was based on something that had not been decided in that earlier order, the service issue, the timeliness of service. So we only have one motion for reconsideration ever filed by Ms. Capone challenging this finding that it wasn't served on time. And you're allowed to seek rehearing once, and she did that, and she did it timely. It wasn't directed to the 2008 order. It was directed to the 2009 order. So, and then that should end it. And I can't, for the life of me, understand why these people are making us still litigate this. Because when it got up to the appellate court, and they looked at the actual record on appeal, it was the day before oral argument, counsel for Philip Morris went to the court and looked in the court file and saw the exact same thing you'll see if you go look in this court's file. I've gone to look at it to make sure. And that is, Mr. Fitzgerald did sign it, and he did date it, and it was served exactly the day that he said. So the original that was filed with the clerk that was in the court file shows it was timely served. So their whole argument that it's not timely is based on a supposition that Mr. Fitzgerald lied under oath, and that you can make that finding even though nobody else testified under oath. Nobody even gave an answer. Once he explained the envelopes, there was never even a response. Philip Morris didn't give any dispute to that. That was undisputed sworn testimony. So you first have to find that Mr. Fitzgerald committed perjury based on no evidence. And then second, you have to find that he, or maybe me, somebody went in and snuck into the court files and switched out a signed version for an unsigned version. And if you look at the appendix to their answer brief,
it's got to have a date and time stamp on the paper, doesn't it?
Yeah. Well, it was received in Miami for filing on the 29th because he mailed it from Virginia on like Thursday the 24th, something like that. And it gets to Miami, so the time stamp on it is the 29th, and there's never been a dispute that that's when it was filed. But, his whole position all along is, how could I possibly have mailed it on the 29th from Virginia and it be received, filed, and docketed on the 29th in Miami?
Is that the case as to all lawyers? Is there an issue about whether some but not all attorneys were served?
Well, there was. Even if he hadn't served one of their lawyers on time, there's never been any dispute that the other lawyer, there were two lawyers. The certificate of service says it went to both of them. Only one of them came to the hearing with his envelope. I mean, we know why. The reason that he did that is because the other one had an envelope showing exactly of a Virginia postmark. I mean, that's supposition, but that's got to be the case. The other one didn't come in. They didn't say they didn't receive it. They said one of their lawyers didn't receive it, and it was a lawyer whose last name was Weil, and the explanation was it was misdelivered to another Weil in a law firm across the street.
So there was never any dispute as to the other lawyer's receipt?
Correct.
You have exhausted your time, but I'll give you 2 minutes for rebuttal.
I'll save it for rebuttal. Thank you very much.
May it please the Court, Jeffrey Michael on behalf of Respondent Philip Morris, USA. And I guess I'd like to pick up on the jurisdictional defect, or as I should say, as Justice Lewis pointed out, there are actually two jurisdictional defects in this specific case that would preclude this Court from reaching the merits of this case. And the first one is the motion for rehearing of an already adjudicated motion for rehearing. We had one motion for rehearing in which this was all relitigated. The propriety of dismissal and the certificate of service issue were all relitigated. That was initially granted. Then later, that grant was vacated, essentially denying the first motion for rehearing. And then instead of filing a notice of appeal within 30 days of that, within 30 days of full adjudication of a first motion for reconsideration, plaintiff filed a second motion for reconsideration. And that is not an authorized motion which would toll the time for a filing of a notice of appeal under the rules. And so that appellate clock ran in the interim while that was being adjudicated, leaving no jurisdiction over any issues that have been raised in petitioner's brief before this Court.
He seems to suggest that there was no final judgment, no appealable order that was of record, as I understood his argument, that after what had happened. And could you address that?
Right. Well, you certainly had a final order of dismissal, and that was the appealable order. That's the order that you filed the notice of appeal saying we are attacking that judgment of dismissal.
And there was a first motion for rehearing,
right,
and that was denied.
Correct. And
so that judgment, you're saying, was final. That's your argument.
Correct. Okay. At that point, you've got a final judgment. You had attacked it once with a motion for rehearing. You lost. You had 30 days to file your notice of appeal.
And how did the third district resolve that particular question?
They did not address that question in their opinion. They instead addressed.
But obviously, you argued. So you argued that it was you filed a motion to dismiss in the third district?
Well, we raised the issue. Yes.
Well, I'm asking because if the appeal was untimely, then did you file a motion to dismiss the appeal?
We instead raised the issue.
The third district addressed in the last sentence, it says that the trial court also correctly vacated the prior order as Capone's motion for reconsideration was not timely filed. So they,
right.
I mean, they did address the
in terms of did we actually file a motion for dismiss in the third district, you don't need to move to dismiss an untimely appeal. You can raise that in your merits brief attacking the jurisdiction, but we raised the issue, certainly.
But what they're talking about there, the motion for reconsideration, that's the question of service of the second one. You're just now addressed the fact that after the first motion for a hearing is denied, they would have had 30 days from that point to file their appeal.
Correct.
Okay.
And we raised both of those jurisdictional problems before the third DCA. The third DCA's decision, I think, addresses only the certificate of service issue. And the certificate of service issue, we have heard before this court a completely new story that is found nowhere in the record regarding a practice by trial counsel of filing signed copies but serving unsigned copies. There were many hearings on this and pleadings in the trial court, and that theory was never brought up. Now, one of the reasons perhaps that it wasn't is it is not borne out by the record. At Appendix Tab Q at page 28, one of the hearing transcripts where they got out the actual certificate of service and the actual filed motion for reconsideration, Philip Morris's attorney specifically says that they pulled the court file and they looked at the court file and it was unsigned. So the idea that they were just looking at the judge's service copy or courtesy copy to Chambers is not borne out by the record. And
well, how could that be if there is one now with a correct or a 29th file stamp on it? How can that be? I mean, those two facts are inconsistent, are they not?
Well, we were surprised when we found in the appellate record a signed copy of that same plea.
Well, I mean, how does can you tell me how a lawyer fabricates a time and date stamp for the clerk's office?
Well, I don't think that can be done.
Okay, so I mean, this record contains in it. Are you saying that the lawyer this morning is misrepresenting something as serious as a filing in a court file?
Well, first of all, Mr. Mills was not representing at the lower court.
A different lawyer. I know Mr. Mills would not.
We simply filed a motion in the third DCA when we found out about this that asked to treat the appellate record as it was clear, the trial record from the hearing transcripts and other papers, as it was clear that the record below was. We did not make any accusations in that pleading. That put the ball into plaintiff's counsel's court. Plaintiff's counsel stood before the third DCA and when asked this question, did not pick up the sword and said, aha, here's what's happened. Instead, proceeded as if the trial record was unsigned below. So the first time we had a real instance of someone weaving together a story that's not in the record and saying this is how everything came to be signed in the appellate record appears in petitioner's brief before this court. So we have no idea how it happened, but we would simply like the record on this appeal, as before the third DCA, to be treated as it appeared in the trial court and as it's clear from the record it appeared in the trial court.
But we wouldn't get to, just so I understand, we wouldn't get to the service issue if you're correct that the second motion was not appropriate, was not proper.
Correct, not authorized under 9.020. Now, stepping back to the merits issue.
Yeah, could I ask you, we seem to have now two different sides. Where are you going to come down on statute of limitations issue? If the statute of limitations on the underlying tort has already expired, does a wrongful death action breathe new life into and create a new statute of limitations under Florida law?
Absolutely not.
That's right. That's my understanding. Right. So
it
that creates
right
a problem in these cases.
It comes right from the text of the statute. The wrongful death statute says that you only have a wrongful death act if there was a viable personal injury act at the time of death.
That's what I thought. Well, I see Mr. Klein's left, so we have to correct him on that. Yeah. So there are situations then where the prejudice to the plaintiff is palpable if you require a new lawsuit to be filed.
Well, we don't think that's the case because we think that even if there's a pending personal injury case and then there's death, you are allowed to amend because you were pleading alternatively and your property were pleading alternatively, you would still have to file that motion to amend within 2 years of the death because
I understand that, but I guess we'll go back to assuming if we have proper jurisdiction on this, because if the third district appeal is untimely, then but they render a decision and don't mention it. Just not sure how that affects, because there's an opinion out there that's may be wrong. How do we deal with that? But we'll have to address that. But on the question of the requirement of filing a separate action, if there is genuinely a question as to the cause of death, that is whether it came from the smoking in the tobacco cases or it was another unrelated claim, do you agree that pleading in the alternative in that same case, being allowed to amend to add the wrongful death action, is the appropriate way to go?
If you have a genuine uncertainty and you properly plead in the alternative, then we do agree that the case did not abate.
But you couldn't plead in the alternative until you sought to amend to add new parties and plead in the alternative.
Well, you're moving for leave to amend with an amended complaint that stakes out your position.
So you wouldn't require under those circumstances for there to be a separate lawsuit?
Correct.
Now, I'm trying then to understand where the plaintiff is not sure. I mean, because at that point, especially if you haven't yet affected service, but you really were concerned about your statute of limitations having maybe run in between the time that you filed it, there wasn't service, and now the person died, you do not want to risk filing that separate lawsuit. You don't know if the defendant's going to agree what the cause of death is. So why isn't it appropriate under any circumstance to allow the amendment of the wrongful death action, which has the same liability underlying it, to be brought in that same case number? That's what we're really talking about, without a separate filing fee. Where is it? Is this a statutory decision or is it a procedural decision?
Well, I think it's primarily a statutory decision with the abatement clause, but that the rule of procedure works with it, because the rule of procedure says you cannot substitute where the claim was extinguished. And then you look at the statute and you say, was the claim extinguished? And the statute says abated, that the claim abates if the cause of death was the same as that underlying the personal injury action. And you can look at this court's opinion in Knowles v. Beverly Hospital, where you used abated and extinguishing in the same sentence, meaning the same thing. The statute and the rule of procedure work perfectly together.
So the view would be that the legislature intended that there would have to be a separate lawsuit filed. That's where I'm having the problem. I understand that what they wanted to do is say, once you die as a result of your injuries, you have no longer an action for the pain and suffering that you endured for whatever it might be, several years. That's out, but we're transferring what your pain and suffering would have been as the decedent, as we said in Martin, to the living, to recover survivor actions and bring it in one lawsuit. And I'm trying hard to understand the policy that the legislature would have in requiring the plaintiff to file and pay a new filing fee and get new service of process, where you have had maybe years, as Justice Quince was saying, of in a situation where you've had years of litigation, depositions, all on liability, not on damages. I don't get it.
Well, my first answer would be the Hawley v. Auld case, where the Hawley v. Auld case, where if the text is clear and the implications of that text is clear, the policy consideration was for the legislature. In terms of why that might make sense if you do move beyond the text is, as we said before, there might be a different personal representative than someone who is associated at all with the case before. That personal representative should have the ability to control the case from the very beginning and have all the burdens of controlling the case from the beginning.
If the plaintiff chooses to file the separate lawsuit, it's interesting. There might be a situation where it's going so well for the defendant doesn't want the separate lawsuit because they have gotten the plaintiff in, there are all sorts of things. Then you'd be saying, no, please, file it in this case. So that's what I think that. Do you agree that there should be a hard and fast rule on this, or should it be discretionary? Because I'm concerned with the game playing on either side. All right, the plaintiff being able to sort of game the system. If a lawsuit's not going well, we're going to choose to file a separate lawsuit, splitting the cause of action, so to speak. On the other hand, the defendant's taking advantage of it. I think it doesn't seem like we should, it should be before the same judge if it's the same underlying cause of action on liability. And that's why it just seems that the amendment fulfills that purpose of both the legislature and this court better. And I would never have honestly thought, I can't, that it was any other way. So I'm trying, again, hard to see the part where it makes sense to file that separate lawsuit.
Right. Well, we certainly,
from the defendant's point of view.
In terms of past practice, Taylor goes back over 20 years. Certainly, in a lot of cases since then, defendants have waived the need to file a new suit, and that's certainly how some of the factual statements got into other cases.
Are you saying, Taylor? You're not talking about, I was thinking Martin, the Martin case. But you said that is Taylor right on point?
Taylor is, as Petitioner's Counsel said, started all of this. And since then, we attached trial court orders from Miami where it has been given effect, and obviously there's been cases where it has been waived because some defendants said, just like service of process, you don't need to actually send a process server. We'll waive that. We'll accept it. And you might say, well, if the defendant has actual service, has a copy of the complaint, who cares about whether or not they were actually properly served? And there would be no prejudice there, but it's a rule, a procedural rule that the courts give effect to.
So is it based on whether there's prejudice to the defendant? Is that how it should be decided? Then it's, again, back to the procedures. Right. Is that the governing principle?
No, I think what we've done is we've attempted to put forth a flexible three-path option for a plaintiff when a personal injury plaintiff dies, for the personal rep to have three paths, and I think our three paths are totally reconcilable with Capone, with Naimi, and leaves essentially no conflict jurisdiction, which is if, as in this case, the petitioner is sure that the death was from lung cancer, and the petitioner's counsel stood before the third DCA and said, I can't say with a straight face that we are pursuing a survival action. We are sure it was lung cancer. If that's the case, you file a separate suit under Capone.
On that one, and you've had 2 years of depositions against the defendant. What is, and we care in this state court system about efficiency and limited trial court resources. Explain from the court's perspective why it would be that if it's the same underlying liability, filing the separate lawsuit is the procedure that we would be requiring.
Well, you have a new party coming in, and it is.
But that's true in the alternative, right? There's a new party coming in.
Right, but the alternative, it's 100% the same damages and same claim. Whereas here, you've got some new survivors who, for the first time ever, have their own claims for damages. And the personal representative owes a fiduciary duty to follow, in some senses, their dictates, and they might not like the first expert. The parties might agree to be bound by the naming of experts in the prior cases.
But it's a question of the parties allowing it rather than it being required. So
Correct.
A trial judge might have gone through and be on the eve of trial, having presided over deposition, discovery disputes, and we're saying no separate lawsuit has to be filed and doesn't even have to be filed in front of that same judge.
Well, in terms of where the lawsuit has to be filed, certainly the county would likely be the same or not. That would be the plaintiff's choice. And then getting to that same judge, I'm sure there are procedural mechanisms to do that, but most of the discovery would be usable. The decedent's deposition, for example, would all be statements that could continue to be used in the same cases. On the flip side, any depositions of defendants' experts, they would likely not be going out to get new experts. All of that would be usable.
Is it usable as a matter of law or discretion on the part of the parties and the court?
Well, for example, the decedent's deposition would be an admission of a party opponent.
What about the defendant's, everything that the defendant has admitted in discovery through request for admissions? Right. Are those binding in the separate lawsuit?
Those would be admissions on the flip side of a party opponent.
So what Mr. Mills says is wrong, where he said that there was no provision that the discovery depositions could be used as a matter of law in the second lawsuit.
Well, it might depend on what the depositions are, but as a general matter, if you had the same opportunity to question the same motives, which for a lot of the depositions it would be, that those would be usable under the rules.
Well, usable as direct evidence? You really think that you can take the deposition testimony in one case and as a matter of law just use that as direct evidence in the second case with different parties?
Well, first you'd have the same defendant. But no, I don't think you can, as a general matter of law, just pick up any deposition and put it into another case.
So but if you're talking about selective things, admissions and other things, not just the general scope of discovery.
Correct. Okay. You would not pick up the entire case file and move it over. And a defendant might have a different strategy in defending against a wrongful death case, which in many cases can be a greater damages case than in defending against a personal injury case, especially if you have young children, survivors, and the like. And some of it might need to be redone at the behest of the defendants, but oftentimes there would just be agreement, just like there would be agreement to allow the amendment if there's no palpable prejudice. But for the reasons that are brief, we think that those three paths are completely reconcilable with Capone and Naimi and Taylor, and that this court, first of all, does not have jurisdiction in this case, but should dismiss.
The Capone court doesn't outline those. You outline them, correct?
Correct.
So if I read this third district opinion, I mean, it says that the original complaint for PI could not be amended on Frank's death to include a new wrongful death claim because Florida law establishes that a PI claim is extinguished upon the death of the plaintiff, and any surviving claim must be brought as a new and separate wrongful death action. Cannot be amended.
Right. And if
that's what the third district says.
And there's
as
no
a matter of law.
And there's no mention of an alternative survival claim. And if you read that and you read Naimi,
it cannot be amended.
It says it cannot be amended if it's abated, which, if you read Naimi, means if there's not an alternative survival claim.
It doesn't say that. Where does it say unless there's a survival claim in this case? It simply does not say that, does it?
It does not say that in the case.
That's fair. Well, I mean, that's just what, and I pick up that case and read it as a lawyer, that establishes that principle of law. I understand your arguments, but the third district didn't accept those or didn't state them in the opinion.
Right, and we would think you'd read it with Naimi, but to the extent that that does need clarifying, I don't think clarifying that portion of it, that it should be read in conjunction with Naimi, would merit doing anything to our underlying case. Thank you.
I have to correct several misstatements. I'll try to do it in the very limited time I have. This business about there being a new party, there's a new party if there's a survival action. It's the personal representative either way, so you always have a new plaintiff. If there's any problem with the language in 1.260A, the solution is for the court to fix that, not to throw the baby out with the bathwater. The misrepresentations that were just made to this court involve the second issue, the jurisdiction issue. It was just stated up here that the first motion for rehearing was denied. That's false. It was granted. You had a final order of dismissal. We timely moved for rehearing. That motion for rehearing was granted. There was nothing for us to appeal until it was rescinded, and it was rescinded on a new basis, and we moved for rehearing on that basis, and we did that timely. The second misrepresentation is Mr. Fitzgerald in the oral argument in the third DCA did not say he's proceeding as if that wasn't signed. He did not say. They said that in their answer brief. I got that oral argument transcribed and filed it and addressed it in the reply brief and said that was a mistaken assertion they said in their answer brief. They've said it again to you today. It's not true. He said he thought that was the case when he was down there, but apparently he was mistaken. You'll just have to read that to find out who's telling you the truth. And then there was a representation that they were looking at the clerk's file down below, and the clerk's file didn't have it. That's not what they were looking at. They were looking at the judge's file. If you read the transcript, you'll see they were looking at the letter to the judge. It was a cover letter to the judge that was signed, and attached to the cover letter was the motion for rehearing that they were talking about that wasn't signed. So if you look at the truth, that second claim falls out. There's clearly jurisdiction here. We make all those in our reply brief. I've just restated what's in the reply brief, but I think that's very important. Thank you very much.
We thank you both for your arguments. The court will now stand in recess for 10 minutes.
All right.
We now come to the third and final case on today's docket, Jackson versus the Shakespeare Foundation, Inc.
May it please the court. My name is Jean Downing, and I'm here on behalf of Carrie and George Jackson. They were the defendants in the trial court below and are the petitioners herein. They are realtors over in Bay County who sold some property, and when they were sued over the piece of property over an issue regarding wetlands, they filed a motion to dismiss requesting that the trial court send the case to arbitration, and the trial court agreed with the petitioners and sent the case to arbitration. And as Justice Periente stated earlier, arbitration is favored by Florida and by the Federal Arbitration Act. It's favored across the United States. It is an agreement of the parties. It saves the court's time. It saves the parties' time. It allows the parties to pick their arbitrator. Rather than trying to file a case to pick a judge, they actually have agreed to pick their arbitrator, to pick somebody who is familiar with this area of law.
But this case doesn't turn on whether one favors arbitration or not. The question is whether there's some kind of independent tort. As I understand from reading the first DCA opinion, that the first DCA has said that even separate and apart from this contract, there's a freestanding tort, and therefore that would not need to go into arbitration. That's as I understand. Is that not what they had indicated?
Yes, it is. It is, Your Honor. And the discussion regarding arbitration goes to the nexus of the case with the contract. The plaintiffs are the ones who filed this complaint, and they attached the contracted issue to the complaint. They referred to the contracted issue in the complaint. They directly referred to the nexus between the arbitration clause and the complaint. The first DCA, in its ruling, said there was no nexus, that this fraudulent misrepresentation case could be completely decided, could have been filed without reference to the complaint. The petitioners respectfully disagree with that, agree with Judge Marstiller's well-reasoned dissent, and would say that the contract has to be referred to when dealing with the issues in this case.
Do you agree that the Federal Arbitration Act does not come into play in this case?
I do not, Justice Periente, because the Florida Arbitration Code is modeled after the Arbitration Act. I believe that the case law, including the Buckeye case that we cited, that those principles of arbitration, those all go.
But you're not. There's no issue about something unique about the Federal Arbitration Act that would govern this.
There is not.
Now, my concern. I understand what you're saying about referring to the contract. What is your argument, though, about that there really are no remedies for the fraud claim? That it envisions that these remedies are really more geared to if there's default by the buyers. So are there remedies if it's to go to arbitration for the fraud claim?
Your Honor, and to answer that question.
By that I mean damages.
Yes.
It seemed like there was specification of damages that wouldn't be applicable to a fraud claim.
First, in answer to that question, I would argue that if the parties in this case, just like the parties in the McGuire versus King case from the 5th DCA, if they limited their remedies by this contract, and there's nothing in the record, because really most of what we have is the complaint, there's nothing in the complaint that says that these parties were incompetent to make this agreement or didn't understand it or weren't anything other than two business entities making an agreement regarding a piece of property. So one, if they did limit their remedies by choosing to select an arbitration clause, choosing to include an arbitration clause, then that's absolutely allowable.
Okay, so I think I'm hearing you say that we would interpret that there is an intentional waiver of common law damages for intentional fraud and misrepresentation, would that have to be litigated by the trial court or by the arbitrators?
Where the issue of fraud doesn't go to the entire contract, it would all go to the arbitrator. The arbitrator would make that decision.
There was as I gathered it, though, and maybe let me just go back again. So I think what you're saying is that the fraud claim could be brought in arbitration, but that the contract clearly limits the damages that are recoverable, and so there will be a waiver of any other damages by virtue of the contract.
That is one argument. I also argue that if at the end of
is that your? I know that's one argument. What I'm asking you is that your argument? That is that rather than they argue that the lack of remedies showed that the fraud claim was never intended to be arbitrated. You're saying, no, that shows that they intended to limit their remedies even for a fraud claim. Is that the position would be that if you look at the limitation of remedies, that just shows that there was a waiver of any common law action and a waiver of damages that otherwise could be recovered?
Yes. I also would submit...
So it's really harsh then. Now we're not just talking about the benefits of arbitration. Now we're talking about losing significant damages that might come as a result of a fraud action.
I disagree to that end. I think that they would be able to still, if they didn't like what the arbitrator decided, or if the arbitrator said there's fraud, but I can't give you damages regarding fraud, I believe that they can then take that issue to a circuit judge.
Under what theory? They're very limited on arbitration awards under the Florida Arbitration Code. You have statutory reasons that you can go into circuit court. I don't know of one of those that just cover what you just said.
And that's true. The arbitration code, I don't know it completely and thoroughly, and this may be one of those instances. I don't...
Well, doesn't the contract actually recognize that the buyer has the right to seek damages in the case of a default?
Yes.
So, and this doesn't the limitations here don't actually address the specific type of claim you're talking about.
No, Your Honor, but
why wouldn't there be a theory that in the arbitration that they could get damages? The remedy of damages is not excluded. That's a remedy. Here we're talking about a particular claim. So is it your position that in the arbitration, there's really nothing that the arbitrator can give for this claim?
No, I disagree. There are damages that are set forth in the contract.
Which is basically refund of the deposit.
Yes, Your Honor.
That's the answer is they get a refund deposit and that's it.
That's what they agreed to.
Yeah.
But they could, so no punitive, it doesn't look like they pled punitive damages, but in a complaint for intentional fraud, you could claim punitive damages, and that would not be, assuming that was part of the damages, that would absolutely not be something that the arbitrator could award. But I'm not sure I understood when you sort of agreed with that, but then said, but they could go to circuit court and get those damages. That's not correct.
I'm going to step back from that position and agree with Justice Lewis that may not be possible.
Let's see if we can walk. Let's see if we can walk through this. There are some types of tort actions, it would appear, that although they may seem to be, quote, related to the contractual relationship, such as Seifert, the wrongful death case, that there's clearly some kind of delineation between the contractual relationship and the tort.
Yes.
But this one gets a little closer than that situation because it has something to do with the status of the land and that kind of thing. So I guess really what we're talking about, the line drawing.
Yes.
So where do we draw the line? We know under Seifert we can't just say because it's related to it that it brings it in the arbitration, but where's that line, and what's the policy about where the line should be, that kind of thing? Let's see if we can go with that way.
The policy is that if there's a nexus between the contract and the claim, that it should be covered by the arbitration clause.
What type of nexus are we talking about, though? Because Seifert recognizes the nexus for wrong. I mean, that the parties would never have been in that circumstance without the contract.
But in Seifert, the wrongful death action was a completely separate. It could have been a completely separate person. It could have been a visitor to the home who could have brought that. In this case, these are the two parties to the contract, and the contract itself required that the buyers conduct a feasibility study prior to the closing on the property. And that is where the arbitration policy falls into place. That is where...
How about under Seifert? I mean, a person wouldn't be sleeping in the house unless they had purchased it, and they would not have died had they apparently inspected it, and we always have, as the normal, we go through and we do a walkthrough, we do a punch list, we do all those kinds of things. I'm trying to see how we fit this one in without violating the principles of Seifert. Can you help with that?
The Seifert case is distinguishable from this case because in Seifert there was an attenuation of time. There was an attenuation between the contract and the cause of action. Here, it's not the case. There's not time, and there's not any difference between the issues related to the contract. The contract itself is for the sale. The dispute is about the sale of the property. The alleged misrepresentation is about the sale. And Justice...
Okay, so I'm getting that. So tell again, but I'm not understanding that if a case is about the breach of contract, that someone breached the contract and you're seeking remedies under the contract, that's the kind of nexus I think that the First District, that Judge Thomas is talking about. But here, if you're talking about a common law fraud in the inducement, where the damages that are being sought are not damages under the contract, the fact that you, as the defendant, may argue a defense such as is, that they accepted it as is, or or that they were supposed to themselves, they don't have clean hands or whatever, you would be saying that because you have to reference the contract, that then subjects it to arbitration. That's where I don't know that nexus test makes sense in the concept of any arbitration clause where you're not seeking damages as a result of the contract.
And I have two different responses to that. The first is that in this case, this complaint, if the court goes back and looks at the first 14 pages of the record, this complaint is not a complaint for fraud, or doesn't say it's a complaint for fraud in misrepresentation or fraud in the inducement. It is simply a complaint. It simply says plaintiffs sue defendants, and then there's...
Is it a breach? Because I'm looking at it. It looked to me, it's not a breach of contract case, is it?
Well, the contract is attached. Well, the contract is referred to.
Says. And as a result of they talk about their fraudulent misrepresentation. As a result of the fraudulent misrepresentation, they've suffered damages. It's not a breach of contract action. And I don't know whether, there obviously wasn't a statute of limitations issue.
But doesn't the operative language here say this: all controversies, claims, or other matters in this question arising out of or relating to this transaction or this contract or its breach will be settled as follows. And then it goes on from there. And it talks about the arbitration. And establishes the right to arbitration. So Unless I'm missing something there, that seems to be pretty broad.
It is the most broad and recognized by this court.
I'm struggling with the concept that somehow a misrepresentation that induces a contract is not related to the contract. And a claim of misrepresentation that induces a contract is not a claim that's related to the transaction or the contract.
Well, and Judge Thomas and Judge Van Nortwyk in the first DCA gave a hypothetical about, well, they could have relied upon the advertisement and made and incurred some costs. Well, that's not what happened here, as the court is saying.
I don't understand that. I don't know how somebody can reasonably rely on an advertisement that they see and go out and spend money before they've entered into any kind of relationship. How do they know that the property hadn't already been sold? I mean, that is absolutely fanciful, the idea that they could reasonably rely on an advertisement to go out and expend monies and reliance on that when the whole situation could change until there's been an acceptance of an offer.
Right. And the reliance here was on the contract. The detrimental reliance is completely tied in and to the arbitration clause and to the contract. It's referred to in the complaint. It's got to be, as Judge Marsteller stated in her dissent, it's got to be read with the rest of the contract. I don't agree that that's just a defense. The arbitrator or the judge is going to have to look at that entire contract to determine whether there was any type of fraud. And while this may say fraud in the inducement, Justice Pariente, they may talk about fraudulent misrepresentation, but the last or second to last paragraph of the complaint requests attorney's fees based on what? The contract. So
I think that, and I think the other side's going to have to answer the question, because I'm reading paragraph 14, the two sentences that Justice Kennedy talked about, and it does say it's broader than, and I stand corrected, than just the contract. It says arising out of or relating to this transaction. So I think that gives you, therefore, I think that the nexus, now whether that was whether, there is some distinction because of the damages that are actually being sought, because there's I don't see a waiver of damages, provision, but that's a question, I guess, for that would be a question for the arbitrator, perhaps. So that's a friendly, that I do see that as being a very broad question, and so really, when you're talking about not torts that are independent of the contract, but torts arising related to the contractual relationship, your position would be that's a sufficient nexus.
It is.
How would you address this or draw the line or separate? Because, there's no question that in Seifert, this court has held that if it is the contract itself that places the party in a relationship that creates new duties, as it says, not otherwise imposed by law, then that's when it comes within the contract. But that if there's an action for a duty not arising from that contract or not in the contract, is arising from the common law duty, how would you square those two cases? Because clearly that's what Seifert has said.
First,
you've read it a lot. You've read it over and over, I'm sure, and dealt with how do I distinguish this and that kind of thing.
First, because this is a broad transactional phrase in the contract for arbitration, and second, because the issues here, the relationship here, the misrepresentation, if it happened as a result of their relationship under the contract, not as Chief Justice Kennedy said, not because there was an advertisement in the paper and they relied upon it. It is purely and solely because they bought this piece of property. And it is important to note that the parties themselves recognize by requiring a feasibility study that there might be some issue with the property, that it might not be proper for the plaintiff's usage. And I see that I am out of time. So unless there's any other questions. Thank you.
May it please the court, let me see if I can deal with some of these issues that have been raised here, and probably not in any particular order. My name is Leonard Ireland. I represent the respondents in this action. Let me first give you a little bit of factual information, which I'm sure you have and what you have, but it's just about a couple of sentences on this. The Jacksons are realtors. They advertise this property for sale through the Panama City, Bay County, multiple listing services, and they put specifically in there two things that I think are important. One is that this is a good project for affordable housing. Number two, and more importantly, that there's a feasibility study been shown that there is no wetlands on the property. That is not true. At the time
in your brief, don't you indicate that there are no jurisdictional wetlands?
There's no jurisdictional wetlands.
Well, now, okay, we get into a little ambiguity there because what it means, then there may be some land that's wet, but you can fill it, right?
Well, let me finish out, if I may, Chief Justice.
Well, if you could answer my question. What it means is that if there are lands that are wet, but they can still be filled if they're not jurisdictional wetlands. Isn't that correct?
I don't believe that's correct, because there is another study which Ms. Jackson had in her possession at the time that she made that representation that said that 26% of this land was in wetlands. Now, if you're going to make disclosure, you've got to make full disclosure. Excuse me.
Didn't you say in your brief, maybe I'm wrong, correct me if I'm wrong, that there are not jurisdictional wetlands on this property?
There are not jurisdictional wetlands on the property.
Doesn't that mean that the land can be filled?
I do not know that. But I know one thing. I know they have not been able to develop this land since it was purchased.
Well, in the contract, doesn't it provide for a feasibility study so that the buyer has to go do its own due diligence and do its work in determining that?
The buyer may, and that may be a defense when we get down the line. That doesn't have anything to do, respectfully, with arbitration.
But then let's get to the arbitration then, because it seems to me, and I think they asked your opponent about this being a very broad arbitration clause. And so there is language in that arbitration clause that talks about relating to this transaction. And that's the language that really, to me, seems to be the linchpin. Why isn't this advertisement related to this transaction?
Because it occurred prior to the time that these parties entered into this contract. The contract has absolutely nothing to do with it. You and Seifert set the board.
Why did you attach, if the contract has nothing to do with it, why did you attach the contract to your complaint?
Probably out of stupidity.
Well, but you asked for attorney's fees under the contract.
And probably based on the same thing. But to get to this point.
But here is the problem I have about what's fair and what's contemplated. And I'm more concerned, actually, with whether there's a limitation of remedy, but let's just stay with the cause of action. They have every right to defend this action for fraudulent misrepresentation by saying that the contract, you bought it as is, and you had the right. That the as is pretty critical, and you would agree they can raise that as a defense to your fraud.
No question.
Okay. That's what I'm saying. It's not. How is that not related to the transaction? You purchased property that you say you wouldn't have purchased if they hadn't made the misrepresentation, and they say, but when we entered the contract, you took it as is. And you could have done a feasibility study. That's the defense. It's not like Seaford, where it's a wrongful death tort action for something that is wrong with the property. I mean, that would be like if a few years later, or even not a few years later, while they were out doing their feasibility study, they fell into the wetlands, and somebody almost had brain damage. Well, I don't think they'd say that goes to arbitration, right?
Three.
You know, so I'm not seeing how this is a broad arbitration clause, right?
It is, no question about that.
All right. So why isn't there the requisite nexus that seems to be the requirement when we say whether this should go to arbitration or go in a lawsuit?
Okay, let me answer that. In Seifert, you said the better reason case started with the premise that in order for the dispute be characterized as arising out of or related to the subject matter of the contract and thus subject to arbitration, it must at the very least raise some issues, the resolution of which requires a reference to the construction of some portion of the contract itself. Okay.
But I think what Justice Kennedy is saying on that one is it's very nice to say you were induced because of the advertisement, but I think we all know that just because you look at a broker's listing, that if there is, if you wouldn't have there has to be something between when you got that advertisement and when you agreed to pay the money, and that's something's called the contract.
But that money could have been, if we'd gone out there and said, okay, we like the property, here's $253,000, give us the deed, no contract.
That's not what happened.
But
I mean, if it did, then you wouldn't have this arbitration
I asked the question
clause.
back, and I know I can't ask a court question, but I ask you to look at what you would need to do. What portion of that contract would need to be construed to give us a viable cause of action? And the answer is none. There was a misrepresentation. It was made knowingly. We relied on it, and we were damaged. None of that, you have to go to the contract. You differ that with McGuire. In McGuire, there was a representation in writing. Excuse me, Chief Justice.
Okay, I'm sorry.
There was a representation in writing that 2 acres of the land that was being purchased had I think, drainage permits for it. They reduced that to writing. There is nothing in this contract that says that land, there is no wetlands on that land. Absolutely nothing in that contract. That you don't have. You could take that contract, put it over here, try the lawsuit on fraud.
See, I think you'd have a better argument if it said arising out of or relating to this contract. But I think the problem about the intent of the parties is that relating to this transaction, we're talking there about the real estate transaction. When you talk about a tort action where somebody dies as a result of something on the property or is injured, it's not relating to the transaction, and that's a pretty easy distinction to be made. But the broadness of that language is hard to get around. I think from your point of view.
The language was the same in Seifert.
Seifert was a broad. That's not accurate.
I think. Well, let me check.
I mean, the Seifert case actually refers to property, which is a whole other problem with Seifert. But if you look at the language, unless I'm missing something, that's not the standard language that's used here. U.S. Homes had its own language.
Yeah, there's no reference to the relating to this transaction in Seifert at all. It's not there.
Well, Seifert says any controversy or claim arising or related to this agreement or the property.
Like I said,
okay.
It's different.
But I think I'll stand corrected, but I believe that they did determine in Seifert that was a broad.
If your client had not entered into this particular contract for the purchase of sale and closed it, there would be no claim for fraudulent misrepresentation.
And that's what the First District said. First District said just because we're there and we're parties to that contract doesn't mean that we have to arbitration.
I'm saying the opposite of that. If you had not entered into the contract and closed it, then there would be no claim for fraudulent misrepresentation. Unlike Seifert, where there was a tort to an individual and the tort occurred without regard to a contract, this is very different. There would be no tort of fraudulent misrepresentation but for the contract and the closing of the contract. That's what gives you the cause of action, and you appropriately attached it to the complaint.
And again, that may be out of stupidity because I could have pled that complaint without having it attached to it.
No, I don't think, honestly, even if you didn't attach it, it still is related to the transaction, which was the negotiation and sale of real estate. That's the transaction. In a tort case, it's not. The transaction is not purchase and sale of the real estate. It's the underlying issue of someone being injured. But address the issue of the limitation of damages.
Thank you.
Because if you go to arbitration, what are the damages that you are allowed to recover?
I do not know. Paragraph 14B of the contract says, all other disputes, buyer and seller will have 30 days from the date of dispute arising between them to attempt to resolve the matters through mediation, failing which the parties will resolve the dispute through mutual binding arbitration in the county where the property is located. And then it says, the arbitrator may not alter the contract terms or award any remedy not provided in the contract.
And what remedy is provided in the contract?
Return, as Justice Lewis said, return of the.
Well, so isn't that, to me, that is either a stronger argument for you that the intent of this was never to be a broad contractual issues about anything that's related to the transaction, but rather a narrow situation where a buyer defaults and does not go and doesn't pay the rest of the money.
Which was the first argument that we made to the District Court of Appeal. The District Court of Appeal came back to this court's Seifert case and distinguished the McGuire case, and that was the basis for the majority in that case. I agree with you. That was my first argument in the District Court of Appeal, is that I don't have any remedy. And as a matter of fact, in my brief, I'll cite to the cases that say for every remedy there must be some, for every wrong.
Was the issue litigated of unconscionability of an arbitration clause, or did we even get that far?
Nothing's ever been litigated in this case, Justice. We were there on a motion to dismiss. The motion to dismiss was granted. We went to the first DCA. I made those arguments for the first DCA. The majority in that case came down on the side of the Seifert case, saying we don't care what it is because it's not related to, we find it's not related.
But it seems to me, see, that's a strain, though, and that's, we've got to look at this for all kinds of situations in terms of interpreting arbitration clauses. And it just doesn't seem that you can construe 14A without reference to, 14B. And maybe, 14 without looking at A and B, because it talks about first deposits and then it has all other disputes, but it goes back to only there's no other remedy that can be provided.
It was recognized in this court by Seifert that in the Seifert case, that was a standard real estate contract. This is a standard real estate contract. We argue, beginning on page 22 of our brief, that it's clear from the terms of the contract that it was not the intent of the parties that the issues raised in this case be sent to arbitration. And I submit to you that that's there. But I guess maybe mistakenly thought that we were here on whether there was a conflict between McGuire and this case.
The problem, McGuire may be different, but it's not a problem, but they certified conflict to the extent there's conflict. We could decide there's not conflict, I guess, and not take the jurisdiction, but they've certified conflict, so to the extent there is disagreement.
To further answer your question, in our brief on 24, I go through all of the remedies that are provided. A remedy for the seller, for the buyer in the event the seller fails or refuses or neglects to perform the contract, in which the buyer may choose to receive or return a deposit. A remedy for the seller if the buyer defaults in the sale and he gets to retain the contract and split it with the realtor. A remedy in the event of disputes concerning entitlement to deposits, failing resolution of the media, the same thing. All other disputes failing resolution media must be determined through mutual binding. So everything that's not related to your normal disputes between those people who buy and sell real estate and the realtors, there is no remedy. There's absolutely no remedy. There's no remedy for actual fraud, which you have said we didn't plead the punitive damages, but that's, as you well know, another step in the process when we get to the record. I fully intend to.
I forgot that they changed the law on that. That's correct.
Once we get record evidence on the as to that being an intentional misrepresentation, then certainly I intend to ask the court to allow that.
So that's really, to me, that's the bigger issue, because I agree that, we've said that arbitration is preferable sometimes because it's more expedient. But when you have no real remedy that you can obtain for the wrong, then I think there's another issue. And of course, that's an alternative basis that you've, that I guess that the First District didn't address, but you're making it here.
And it appears that there are differences. There are torts and then there's torts. And it appears that when you're dealing with the tort of fraud, that it requires one step that's far different from all other torts that we look to, and that is that attempted frauds are not actionable.
Sure.
And again, as you, rightfully, candidly said, without saying I'm buying this property and coming to the agreement, there's no action because that's one step that's needed. That's pretty clear. And in some cases, it may be reduced to writing. In other cases, it may not. But in real property in Florida, our statute of frauds require to be reduced to writing. So that's what I'm struggling with, is that the tort of fraud in real property just seems to flow to that contract.
But the public policy of that, Your Honor, is that if the defendant in this case is allowed to get by with this and to send this to arbitration where there is no remedy, then...
Well, I agree that maybe that's maybe a different theory. I'm just talking about specifically if let's say the contract said that any claims shall be decided in accordance with Florida law, and that's it. Then would you be bound by arbitration?
No, I don't think so.
Okay, because that would seem to be that that to me, if you don't go after this remedies aspect, makes it pretty tough to proceed here. Is what my concern is.
Justice Overton, in your Seifert case, in a concurring opinion, said, I want to make it clear that if people are writing these kinds of contracts and want to be protected by those contracts, they need to make sure, number one, that they write in there that it takes care of everything, whether it's fraud, torts, whatever, and also that the parties by this provision waive their right to a jury trial on such contracts. This is a concurring opinion, Justice Overton, in that case. I agree with you completely, and as I said, and I probably repeat myself, that was my first point that I raised before the First District Court of Appeal. They decided to go a different road.
Well, but that doesn't preclude you. If we were to say that there is that the issue of an unconscionability has not yet been raised.
No.
So that nothing precludes you from raising it upon. If we were to quash the First District opinion to say, well, you can raise unconscionability.
I don't know where I would raise that, though, because if the First District is quashed, then I'm back to arbitration, and I don't know that that's something I can raise in arbitration.
The trial court decided it had to be arbitrated.
Yes. Trial court granted a motion.
At that time, didn't you have an opportunity then did you argue in the trial court limitation of remedies?
Yes, I did. And it was just basically, as I recall,
it would go back for the for the trial judge to look at the alternative ground of limitation of remedies.
Whatever the court decides, the court in its wisdom wishes to do.
Well, I'm just trying to figure out that.
Well, it would require a special decision to say that, because if it doesn't really direct the trial court what to do, it is remanded, and then you have a dismissal.
We're back to dismissal and sent to arbitration, right, and then have to go through the process of arbitration, which, as you well spelled a while ago, is it's pretty much in the hands of the arbitrator. Unless there are any other questions, I think I've pretty much exhausted most of my time. Thank you very much.
You've got 10 seconds.
I think I had 10 seconds.
I'll give you an extra minute.
And Justice Lewis, you asked me earlier about does Florida allow, and something that was said made me look back in my file, and one of the arguments that I made to the trial court regarding limitation of remedy is that under Section 682.12 Florida statutes, a party can seek to have an award confirmed or under 682.13, a party can seek to have an award vacated for, among other things, if an arbitrator exceeded their powers. So there would be a place for the defendants below to
exceeded
make
their powers. That means that they've gone on to decide something that's not arbitratable. But if it is just the damages, I mean, that's, you can't challenge if the contract says return of money, and that's what the arbitrator does. That's not going to be a statutory basis to set aside that arbitration. Inadequacy is not a basis, as I recall, under any element statutorily to set aside an arbitration. Manifest weight of evidence, any of that stuff. I mean, our normal things we think of, we're really limited for judicial review. I mean, aren't we?
If we are, then I'm going to go back to the argument that the parties agreed to limit their damages, and that has been argued before the trial court, and the trial court dismissed this and sent it to arbitration. And I thank y'all for your time.
We thank you both for your arguments. That concludes this session of the court.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.